There are basically two major changes that have come up recently. The first one is a decision of the Court of Justice of the European Union called the Schrems II decision. And basically what the court did, based on sort of the template of the transfers made by Facebook from Europe to the US, they looked at the various safeguards in place and came to the conclusion that in the end, at least some of those safeguards were not sufficient. For instance, the EU-US Privacy Shield has been considered inappropriate and been invalidated, but also for other means of transfer like standard contractual clauses. The other major change is around the relationship with the UK, with Brexit. With Brexit complete now, from a GDPR perspective, the UK is considered a third country, the same way as the US or other third countries. And so the question is, what about data transfers? Do I need to put in place the same safeguards than I would have to with the US, for instance? Fortunately, for now, the answer is still no, because there is a trade agreement between the EU and the UK. In that trade agreement, there's a sort of a transition period up to 6 months, so till end of June of this year. And as long as this is in place, data transfers can still take place as usual.
On my side, more from an operational standpoint, I think it's nice time also to revisit what has been done at the time that GDPR project has been enforced back in 2018, potentially a bit earlier, a bit later. I'm sure that the register of data processing that has been put in place at the time is not completely accurate anymore. So this is likely to be the right moment to think about what has been changed, not only in terms of data transferred outside of the EU, but also more globally as to how data are processed within the organization.
At the beginning, right after GDPR came into force, everyone looked sort of at the literal text and cared about, okay, I have 72 hours to notify the regulator in terms of a data breach, and that was it. But in the meantime, we have had a lot of practical situations that occurred, actual data breaches. And with those come the actual practical questions. How do I deal with the different issues? And that's something that we picked up with the GDPR working group of ALFI, and we expanded the section in our Q&A on data breach from a few paragraphs to a number of pages. And one example of the things that might not be entirely clear to everyone is something as simple as what actually is a data breach. Not everyone, even today, knows that a simple loss of availability of personal data, so without anyone having stolen any data or accessed it, but the mere fact that the data is not accessible anymore, can already be considered a data breach and may need to be reported to a regulator. Other examples are around when exactly do you know that there is a data breach? What's the difference between a simple incident in your IT systems and when does it really become a data breach? It should in particular also not be forgotten that funds, for instance, often have additional reporting obligations on top or next of those of their service providers. Another point that we have looked at is the interaction between reporting obligations under the GDPR and under other regulations. Is it really sufficient just to inform the CNPD in case of a data breach? Do you also need to inform the CSSF? And how exactly do you deal with this? What about a cross-border breach if it's impacting entities in your structure throughout Europe? How do you deal with this? It's really an area in constant evolution and there are still open questions, so it's really something to pay close attention to.
I think one of the first points to consider is having a register of the breaches, because it will help demonstrate that there is a proper governance around the identification, around the analysis and the assessment of what happened. So the register of the breaches is the first item to consider. The second piece of advice I would have is obviously to conduct on a systematic basis a post-mortem analysis of the breaches to understand what happened and to remediate, potentially change processes, review information security measures that are put in place so that the company minimize the risk of such a breach to reoccur. The third item I would advise, and I'm sure that we all agree on that, it's about training and continuous awareness of staff and of each and everyone within the company to make sure that A, the information security measures are properly understood, and B, that when something happens, that make sure that the DPO or whoever is in charge of data protection is properly informed of something happened. I think it's a key point here to understand that the weakest link usually is the human being, is us as individuals, as employees of the companies, and this is really where a continuous focus should be put on. A nice way to look at this is obviously not to only count on the DPO, the data protection officer, or the data protection manager that might have been appointed instead of a DPO, but it's also to make sure that the second line of defense, like the compliance function, is properly taking on the GDPR compliance challenges. What we see on the market, and what I strongly advise you to consider, is having a proper plan, compliance monitoring plan addressing the GDPR requirements. Why is it important? It's because, as said, the DPO is not personally responsible for the compliance of the organization with the requirements. It's the company itself. So making sure that the second line of defense is properly equipped and knows what to do to ensure that operational ongoing compliance is key. How to do it? That's one of the questions that we get asked the most. I strongly advise you to look at the FAQ that we've been doing as part of the ALFI working group, because we designed and we propose the basis, at least, or what I believe is more than just basis, but a basis of a good compliance monitoring plan addressing GDPR. Another good reference that you can look at is the CARPA methodology that have been developed by the CNPD. Also, CARPA is a certification mechanism. It gives very interesting insight as to how a data protection regulator, would look at compliance with a regulation. So it talks about governance, it talks about what to do when acting as a data controller, what to look at when being engaged with data processors. So all this should form the basis, as I said, of your ongoing compliance monitoring plan to ensure that you are not too much subject to potential fines from the authorities.
We all have heard that GDPR can come along with very high sanctions, up to 20 million euros or 4% of global turnover. What is maybe a bit lesser known is Article 83 of the GDPR, which basically sets up a number of criteria for regulators to take into account when they have to decide on sanctions, on what sort of aggravating or diminishing criteria might be in terms of sanctions. And there the concepts of accountability, cooperation, and so on and so forth really come to life and have a real life impact, a financial impact on the potential sanctions that can be issued. So having a comprehensive compliance monitoring program shows that it's, maybe you have made a mistake, everyone makes mistakes, it can happen, but you had everything in place to catch your mistakes and to remediate. Whereas if you have nothing in place, then you are off to a bad start with the regulators.